It is really an honor to have the opportunity to introduce to all of you a friend, a mentor, a hero, someone without whom, quite literally, we would not be here today. Assemblymember Kalra represents California's 25th Assembly District. It encompasses the majority of San Jose, including downtown and open areas in southeastern Santa Clara County. He was first elected to the Assembly back in 2016. He became the first Indian American to serve in the California legislature in state history, and he was re-elected to his fourth term in 2022. Assemblymember Kalra is currently the chair of the Committee on Judiciary and also serves as a member of the Housing and Community Development, Local Government, and Natural Resources Committee. He's chair emeritus of the California Legislative Progressive Caucus and works to ensure that key legislative priorities are successfully passed on civil rights, criminal justice, economic and worker justice, environmental justice, and housing justice. Previously, he served as chair to the Assembly Committee on Labor and Employment and Assembly Committee on Aging and Long-Term Care. Assemblymember Kalra has dedicated his tenure in public service to equity and social justice issues, to confront racism and systemic bias in our systems of justice. He authored the historic act that brings us together today, the California Racial Justice Act of 2020. We've been listening to experts and discussing what that act is all about, and in a few moments, we're going to have the opportunity to hear from the man who wrote it. He's continued to dedicate himself to this cause, doing follow-up or cleanup legislation almost every single year since that act was initially passed and signed into law. But it's not just public safety or racial justice that Assemblymember Kalra champions. Like so many of us in this room, he understands all too well the connections between public safety, between racial injustice, and the upstream problems that are all too often ignored by those who focus on tough-on-crime responses. Economic inequality, housing inequity, environmental injustice. And so Assemblymember Kalra has been a long-standing champion of critical issues when it comes to public safety that we don't always think of as public safety issues. Things like single-payer healthcare systems. He introduced AB 1400 in 2021, the statewide legislation also known as CalCare, which would guarantee comprehensive, high-quality healthcare for all Californians as a human right. He has advanced a wide number of issues to assist our aging population, like expanding the assisted living waiver program, and to protect our public health, like reducing worker exposure to lead poisoning. To safeguard nursing home and long-term care facility residents, he authored AB 323, also in 2021. He's busy. He's writing more laws than you are writing motions, which updated citation penalties and standards for negligent care. Assemblymember Kalra has consistently put forward solutions to help alleviate our state's housing crisis and to encourage compassionate and thoughtful assistance for people experiencing homelessness. Back in 2019, when some of the law students in the room hadn't even taken their LSAT, Assemblymember Kalra authored AB 1745 to extend the authority of the city of San Jose to develop emergency bridge housing communities to help that city's homeless population transit into permanent supportive housing, right? We know that's one of the things that's most critical and fundamental to actual public safety and to what makes people feel safe. Assemblymember Kalra also secured $2 million in the state budget to extend the city of San Jose's eviction diversion program, which has prevented over 100 households from being forcibly evicted, and by providing targeted gap assistance to low-income households on the brink of eviction. I could go on and on about his phenomenal record. He has done so much for the state, for his hometown, for all of us. But I would be remiss if I didn't mention that in many ways his career started where so many folks in this room's careers have started. He spent 11 years as a public defender in Santa Clara County. And during that time, yeah, go ahead, give it up. He did dozens of felony trials. He represented indigent clients in both felony and misdemeanor matters, and a significant portion of his time as a public defender was spent in drug treatment courts, making sure that his clients had the opportunity to complete rehabilitation programs, to turn their lives around, to get off the street and on their feet, and to be off-ramped from the punitive and destructive consequences that all too often come with a criminal conviction or sentence to incarceration. Assemblymember Kalra was not born in California. He was born in Toronto, and like so many immigrants, he came to this country following a dream. Came to California as a child, and he continues to reside in the same San Jose neighborhood where he grew up. He received his Bachelor of Arts in Communication from the University of California, Santa Barbara, and he received his law degree from Georgetown University. He's our champion, and it is my privilege to be able to delay just a few moments longer the moment you're all waiting for. No, I'm just kidding. You're ready? Come on up, Assemblymember Kalra.
I knew it was going to be that long and kind of an introduction. I would have pulled the fire alarm myself. I do want to thank all of you for being here. I want to thank the Berkeley Criminal Law and Justice Center and Berkeley Journal of Criminal Law for their work in hosting the 2024 Racial Justice Act Symposium. That sounds really cool. I didn't know when I introduced the bill that we would be having symposiums on this someday, but it's really a testament to the work of so many people that were here today. And I want to give a special thank you to Chesa Boudin, not only for inviting me to share my experience and insight today, but for really being a partner in justice for so many years, including in supporting the Racial Justice Act when he was DA. So, it's amazing that you spent the day in this symposium with such a fantastic opportunity for everyone to come together as we envision the future of what this law will be, how we can improve its implementation, and really continue to work to dismantle the racism that has proliferated throughout our criminal legal system for generations. You're at the forefront of this work in every different capacity that you all hold. And as mentioned, I represent the 25th Assembly District in San Jose, where I grew up. But prior to that, being the Assembly, I was on City Council, and as you just heard, a public defender in Santa Clara County. I know some Santa Clara County peeps are here. And that time, those formative career years really shaped who I am as a legislator. The way I kind of feel like we infiltrated the legislative system with the public defender. And, right? And I'm just doing, my work is to help all of you that are doing the real work on the ground have more tools and have more backup. During my time, and I was a public defender, from 97 to 2008, and anyone that was a public defender or worked in the criminal justice space in the late 90s into the early 2000s knows how daunting it was. And none of us that have been in that space are surprised or need to be told about how racism infects and is injected into every aspect of the system. And so with the experience as a public defender in hand, with my work on the city council, trying to uplift working class neighborhoods, in the state assembly, I was approached by the Anti-Death Penalty Coalition towards the end of 2019. And after discussing it with them and understanding that this is the right time to actually tackle, implicit by to tackle in a real way racism in our criminal justice system, we embarked on this journey in early 2020 with a powerful coalition of criminal justice advocates and legal experts no longer willing to accept racial bias in the criminal justice system as an unfixable item that just is going to be there no matter what. However, we introduced the bill in March of 2020. So we all know what happened in March of 2020? Well, in less than 2 weeks after introducing the bill, the state shut down. and probably at least 80% of legislation that had been introduced up until that point was set aside. And, you know, a lot of really good bills were introduced. It wasn't just the Racial Justice Act, but, you know, given how powerful our intro was on the steps of the Capitol, it just seemed unjust that we had to wait even a day longer. It definitely seemed inevitable that the Racial Justice Act would have to wait, despite the mounting evidence clearly demonstrating the worst racial disparities in our criminal legal system, a system that for over 3 decades had allowed the McCleskey v. Kemp, you know, one court ruling to ignore that racial bias played, the role that racial bias played in criminal judgments, because doing so would be too difficult to remedy. I know that you've been discussing the data and all the disparities, and so I'm not going to go through some of those disparities. I think all of you, for many years, have lived those disparities in the courtroom and representing individuals or having families or being the accused or having being families of the accused understand the disparities that had existed, and even those disparities that were pointed out in the McCleskey v. Kemp case, where they admitted that racism played a role, but basically just said, oh, well, that's just how it is in this country. The Racial Justice Act was put to the side, and we had to wait. But it was resurrected, because what else happened in 2020? The torture and murder of George Floyd. And so when that had happened, it set in motion a movement for racial justice that many of you, I know millions were out in the streets, that undoubtedly galvanized our need to rid our criminal justice system of the ills of systemic racism. And so, as I talk about what happened, you have to understand this is very unusual. The fact that the Racial Justice Act even came into being was against many, many odds. Not just the fact that a bill of that nature could even be introduced or moved to the legislature, but everything that was happening around it. What we did was we did reintroduce the bill in a controversial method called a gut and amend process. We introduced AB 2542. And so what a gut and amend means basically is we had introduced it in the Assembly, the bill died. We went over to the Senate and we found a vehicle, which basically means a bill that wasn't moving. And we got the language of the Racial Justice Act, we gutted out the other language, and we stuck the Racial Justice Act language into that bill in the Senate. And that is what kind of was the new rebirth of the Racial Justice Act later on as we had entered into summer. And so it laid the foundation because we knew that that as the bill moved forward, it was going to face a lot of hurdles. And so what happened was it was in the Senate. It went to the Senate Public Safety Committee, and we had to argue in the Public Safety Committee why it was necessary. And during the Public Safety Committee, and this is during COVID, so folks are masked up, and it was kind of very dramatic. Everything happening at that time was dramatic. But the fact that we had kind of resurrected this bill. And I remember because when I was presenting the bill, and we had Public Defender Brendan Woods was one of the witnesses that testified. When it got time for the opposition to testify, and usually, if you're in favor or against, the witnesses get only like 2 minutes or 3 minutes tops. And you only get like 2 witnesses. So it's not like you're up there for hours and hours. You only get a defined amount of time. As the author of the bill, I can speak freely on it, but as far as getting witnesses are basically just folks that are going to speak on one side or the other. And so over the telephone, I hear that on behalf of the California District Attorneys Association, Santa Clara County Public Defender Jeff Rosen was going to speak in opposition, and he had one of his deputies speak in opposition. So it was interesting, from my hometown. I don't think that was an accident, but that I was facing opposition from every corner of the state, including from back home in San Jose. Nonetheless, we continue to push forward. It got through committee, and the thing about the Racial Justice Act, it was its first of its kind, and it allowed us, in a truly meaningful way, to confront racism in our courts. You've heard a lot about that today. And we think about the goal we achieved in that act, it's probably something most people thought was already in place. My colleagues did, right? That's still allowed. They can't challenge that. The fact that you can seeking or obtaining a criminal conviction or imposing a sentence upon race, ethnicity, or national origin is prohibited. There's a presumption by folks that have not been, even some that were lawyers that just have never done criminal law, that was already the case, that it was already not permitted, that of course we shouldn't allow these disparities to occur. And so a lot of the legislation process is an education process, right? We're educating my colleagues, we're educating committee staff on what's really happening on the ground and what the state of the law is. And so we were, although racial bias on paper is not allowed, we were really educating to our colleagues that the act was taking it a step further to acknowledge its existence and empower defendants to object to charges, convictions, or punishments based upon race, ethnicity, or national origin. Just as prosecutors have powerful tools to bring charges and convict, we must wield powerful tools to be that counterbalance for justice. And, when we looked at how the bill progressed through the legislature, I'm kind of laughing because the whole thing was kind of a mind-boggling experience. One of the most unique experiences I had in pushing forth legislation. It made it through public safety, and then it goes on to Appropriations Committee in the Senate. And it got through the Appropriations Committee, even though there is a cost involved, right? There's cost, and DAs need more money, the courts need more money, public defenders need more money in order to have these challenges. But the thing that happens, especially in Appropriations Committee, whether it's the Assembly or Senate, is they do look at those costs. And we had a very difficult decision to make because in order to save costs, one of the recommendations, they say recommendations, but basically it's forced upon you as it goes through the process, right? So Senator Pope said you have to get rid of retroactivity. And a key tenet for all of us, for myself and the coalition pushing this forward, was that we're not going to leave anyone behind. We're not doing this unless we're doing it for everyone. And so that was one of the most difficult aspects of moving the bill forward. We made the decision that we were going to agree to retroactivity because it was so important to get this law in the books, that it still was going to matter, obviously, for those coming through the justice system. And so as the bill went forward, it went to this. So this is another aspect of it that was kind of wild. So it hasn't gone to the Assembly yet. Even though I'm an Assembly member, I mentioned the gut and amend process, right? It's in the Senate this whole time. It still has to come back to the Assembly at some point, presumably go through Public Safety Committee at some point, get referred back to Assembly Appropriations, and get to the Assembly floor. But it's sitting over on the Senate. It's sitting on the Senate floor, and it has not been brought up. And we're getting close to the end of session. It's mid-August. It's getting close to the end of August. We're getting to our final week of session. It's still on the Senate floor and hasn't been brought up for a vote. We're then on Friday. Session ends on Monday. Now we're Friday. Because session ended on Monday, we were in session even over the weekend. On Sunday, I recall we're in session. And I'm like, just kind of begging someone take it up. Part of the reason why they weren't taking up, well, there's a lot of reasons why. A lot of it has to do with kind of inter-house play between the Assembly and the Senate. Also, there was another bill that our now Secretary of State, Dr. Shirley Weber, had specific to jury instructions or jury selection, but they felt may have been, for some reason, a more challenging bill to get through, so they're waiting for that one to get heard. So now we get to Monday. This is the last day of session. If it does not get through the entire legislature on this day and sent to the governor's desk, it's dead. And so it's 11 in the morning, 12, 1, 2. It gets to the afternoon of the last day of session. Sometime in the afternoon, like 3 o'clock or so, is in my memory. Everything was kind of hazy. And it gets heard by the Senate finally. And it gets through the Senate. And so we're like, okay, send it over. It gets sent over. And thankfully, our speaker kind of waived. It wasn't just that bill. There were like 3 or 4 other bills as well. but because of timing, there wasn't enough time to take it through committee. So we basically just had it sent directly to the floor of the Assembly. And it was around 5:30, between 5:30 and 6 p.m. So basically in one day, it got through the Senate and now was brought before the Assembly. Not just one day, in less than 3 to 4 hours, it was on the Senate floor and the Assembly floor. That's not normal. And honestly, one of the good things is that the cops and DAs were busy with other bills. I don't think they thought it was going to be pushed and moved that quickly. I think they thought it was dead. And they're focusing on all of these bills, that kind of anti-police violence bills and all these other bills, great bills, righteous bills we're working on, but they're paying their attention to all these other bills that are on the floor and making their way through. And so they didn't have time to react. And so we bring the bill up, and there's 80 legislators. We need 41 to pass it. I think we got like 49 votes, and it got through. And so it passed on its first year in the legislature, and I still don't think a lot of my colleagues understood how significant it was what they had voted on. You know, maybe now some of them are starting to see, but it was extraordinary. And everyone involved was kind of stunned. Even in retrospect, when we all got together later on to celebrate a few months later with the whole coalition, we were kind of stunned about it. But as I said, we were not going to leave anyone behind. So ordinarily, you pass a bill like that, that strikes retroactivity, you have to wait a few years. You wait 2, 3, 4 years. Okay, now we just did it. We'll come back and now let's look at retroactivity. But we said no, we were not going to leave anyone behind. So the next year, we went back with retroactivity and introduced AB 256, the Racial Justice Act for All. Nobody left behind, especially those who have already been harmed by unfair judgments that were tainted by blatantly racist statements by attorneys, judges, jurors, expert witnesses, or the intentional exclusion of all or nearly all Black or Latino people from serving on a jury, or stark statistical evidence showing systemic bias in charging and sentencing. The systemic racial disparities are pervasive in mass incarceration in this state, everywhere in this country. And according to the Public Policy Institute of California, 4 out of every 10 people incarcerated in state prison are African-American men, which we know is 10 times the imprisonment rate for white men. So with AB 256, we answered the simple question. If prohibiting racism in our courts and providing a person a means to remedy racial bias in their case is the right thing to do going forward, shouldn't it also be the right thing to do for everyone, regardless of when the judgment was rendered? And so throughout the process, we worked extensively with the Judicial Council and policy committees to draft amendments that would address workload concerns with the courts by setting a phase-in for retroactivity, as well as taking technical amendments at their request and of stakeholders like the California District Attorneys Association. We tried our best to understand legitimate concerns folks had. Of course, the DAs didn't want it to pass at all, but they also had some other technical concerns and cost concerns, and we want to make sure that we're at least addressing the legitimate concerns. We had to fight for immediate retroactivity for individuals facing death row or deportation, the urgent consequences that we can't take back. And so that's why they were the first group in phase 1 in the retroactivity. Whether it was serving as witnesses to share lived experiences of racial discrimination in our justice system during policy committees or contributing to the outpour of support across social media and over the phones, community engagement was key to reminding the legislature why the Racial Justice Act for All was needed. It was both the inside and outside work for the bill. Inside, we mean like in the Capitol, outside, everybody that's advocating outside. That was critical in keeping it alive. In its first year of introduction, it was placed on the Senate Appropriations Committee suspense file. So that made it a 2-year bill. So unlike the Racial Justice Act itself that got through its first year, retroactivity, much because the cost was delayed into the second year. So we had to keep the pressure on because the suspense file is oftentimes where bills go to get killed quietly. And in the end, it was a 2-year effort backed by a coalition, 10 passionate sponsors, and over 150 organizations in support. AB 256 is actively being rolled out, with individuals currently incarcerated for a felony being the most recent group to join those who can file a Racial Justice Act motion starting this year, starting this past month. We know with all this progress, there's still much work to be done, And it begs the question of where we go from here. How do we ensure the smooth implementation of California Racial Justice Act as we intended? And, you know, when I think back of 25 years ago, where the criminal justice system was and where we are now, we made a lot of wonderful changes. And look, none of this would have happened without the advocates, without those fighting for it, but it also wouldn't happen without my colleagues. I mean, I get credit as one individual legislator, but it takes a lot of legislators to pass bills and to be co-authors and to stand, you know, on the right side of justice. It also takes governors. Governor Brown and Governor Newsom have signed a lot of really, really good criminal justice reform legislation. And so we know now we're in a very difficult place. The media, opportunistic politicians are taking advantage of a false narrative that crime is through the roof, crime is up, and that now we have to roll back some of the things we've done in the past. Not suggesting the Racial Justice Act will be rolled back, but they're talking about Prop 47. You know, they're not even using, like they just make up arguments. And we have to be very cautious because what the Racial Justice Act is intended to solve for is going to perpetuate if we go backwards on some of these criminal justice reforms, even if it's outside of the Racial Justice Act, because obviously the Racial Justice Act really is an umbrella piece of legislation that looks at so many other laws that have been passed over generations that feed into systemic racism and bias. We know it's going to cost money. I mean, last year we secured $8 million in funding to ensure enough defense counsel could take on the caseload as the result of the Racial Justice Act. But we had to think strategically about our priorities amidst a bad budget year. So for last year was ensuring there was money to take on death penalty cases, where at the time there were 655 people sentenced to death and less than half had an attorney. So we knew that was our highest priority. People on death row, let's make sure we at least get the resources to them. We know this year we're even in a tougher budget year. So we're going to do what we can to fight for resources for public defenders, fight for counsel, not just the Racial Justice Act, but across the board. Because as we've made reforms of our justice system, public defenders have expanded in a good way, and county probation and social services and nonprofits working in tandem have been able to do things beyond just focusing on whether someone gets incarcerated or not. We can actually focus on healing and rehabilitation and job placement and housing. I remember during the pandemic, outside the jail, our public defenders were there helping with folks getting out of Elmwood and that didn't have housing during the pandemic. Those are the kinds of things we can expand more into if we have the resources. And I know it's going to be tough to get them this year. When we wrote the Racial Justice Act, we ensured the state was obliged to provide counsel for individuals filing retroactive claims, and it's our responsibility to get the money to fulfill that requirement. So I definitely look forward to the work to be done and why symposiums like this are so important. And I did a forum like this with Los Angeles District Attorney George Gascon. That was so important, bringing together individuals who are litigating and studying the impacts of the Racial Justice Act. What you all are doing is incredibly important because this is laying the foundation not just for our state, but for the nation. Other states have inquired about how they can get this done in their states. So we know that the data is on our side. We know morality is on our side. We know justice is on our side. But that doesn't always mean that justice is served. And we all, in this room of all people, know that. So we need to be able to actually access the tools necessary to demonstrate the very discrimination that we are witnessing in front of us. The cell phone cameras, what we saw with George Floyd, and so many, that's one aspect of bringing public awareness. But the other aspect is actually speaking to what we're seeing, that when the cameras aren't, what you see when the cameras aren't there every single day in the courtroom. That's why you're the truth tellers and the ones that are going to make sure that this act, but long after I'm gone, long after a lot of us are gone and doing our work, is going to forever change our justice system. Because this is in the short term about, yes, overturning convictions, getting new trials, shortening sentences, getting people out of jail, getting people out of prison. In the long term, it's about behavior change. It's about recognizing that we've had behaviors in our system that are embedded in slavery, that are embedded in racism, that are embedded in socioeconomic bias. It takes a lot to kind of root that out like a cancer out of your system. And so this is about creating a new generation of police officers, of prosecutors, of defense attorneys, and judges who understand instinctively that we can't allow this to continue. It will take time to do it, but with this act and with the follow-up acts, I have the fourth bill I've already written on this is this year. I've done 4 RJA bills. The first one, the retroactivity, we did another one last year, and this year we have AB 2065, which will improve access to data per the requirements to file an RJA motion so that you can actually get the data you need. So I think I'm going to write a bill on the Racial Justice Act every single year I'm in legislature. But the reason why is because you're giving me feedback. You're saying, hey, we need this. Hey, this needs tweaking. This needs fixing, right? So you have to keep on giving me that feedback. And you know, we do have the opportunity to fix this system forever for the good, to use these tools for the betterment of justice. And so it's definitely an honor to be here at the symposium. You know, I get a lot of credit for the Racial Justice Act, but literally hundreds of people played a huge role in making it happen, and thousands, yourselves included, play a huge role in making sure on the ground that it's actually achieving its desired goal. I have a Google alert whenever Racial Justice Act comes up anywhere in the media, and it's so rewarding to see judges applying it and defense attorneys challenging based upon the racial justice. I mean, it's amazing to see the results. We're seeing police departments being exposed, and you know, that's what I mean by rooting out this infection, this disease. And the Racial Justice Act is that medication that can do that. And you're the ones that are applying it. You know, you're the ones that are actually making it happen. So I want to give a special shout out to all the public defenders here and on the Zoom. You're the ones that, you're the soldiers, you're the ones that I'm just doing my best to give you the tools and the ability to fight like hell for the indigent, fight for those that need your voice, that need your passion and commitment. I can't tell you how many public defenders I've spoken to in the last few years that have been so passionately applying the Racial Justice Act, and obviously the offices that have their units. It's great to see some of the DA's offices that have their units, like in LA, and Chesa Boudin was a big supporter of the Racial Justice Act, Diana Becton. But I want to give a special shout out to the public defenders out there. I never imagined when I was a public defender that I'd be in a position to be able to do what I've done as a legislator. And when I think back, I want to give a special shout out to my roommate from college, Justin Tuttle. He's been a public defender now for over 25 years, over 15 years, Ventura County. When we were running around at UCSB, never imagined that we would be doing this work for justice, and to think about the change we're making. So for people like Justin and all the public defenders out there, I'm just trying to give you as much backup as I can. And so I'm grateful to each and every one of you, and I'm grateful that we are doing what we can to make sure that the Racial Justice Act is going to not just stand the test of time, but it's going to forever transform our justice system. And for all of you making that happen, I'm very grateful. Thank you.